The attorney's name was Michael Reeves, employment law specialist. I explained the situation in 10 minutes. Send me everything. The NDA, the contract, the termination letter, any documentation you have of your work communications. I sent it within the hour. He called back the next day. Your contract is clear. Termination for cause requires documented evidence within 48 hours. They haven't provided it. What does that mean? It means they're in breach of contract. Even if you did violate the NDA, which I doubt based on what you've shown me, they failed to follow the contractual termination procedure. What's the next step? I send a demand letter. We request the documented evidence they're required to provide. We also request payment for the remainder of your contract term. How much is that? Your contract runs through December, 8 months. What's your monthly rate? $12,000. So $96,000 total, plus legal fees if this goes to court. I thought about it. Send the letter. I'll have it out tomorrow. The demand letter went out on April 10th. It was professional, direct. Key points. Contract requires documented evidence of violation within 48 hours of termination. No evidence has been provided. Without proper documentation, termination constitutes breach of contract. Demand. Full payment for remaining contract term, $96,000, or reinstatement with back pay. Response deadline, 10 business days. The letter gave them until April 24th to respond. I didn't contact the company. I didn't reach out to former colleagues. I didn't post on social media. I just waited. During that time, I reviewed everything I'd documented during my 18 months at the factory. I'd been meticulous. Every process improvement I'd recommended, every efficiency gain, every safety enhancement, all documented with timestamps, approvals, and implementation records. I also had records of every conversation about manufacturing processes, meeting notes, email threads, internal memos. I organized it chronologically, created an index, saved multiple copies. April 24th arrived. No response from the company. Michael called me. They missed the deadline. What happens now? We can proceed with litigation, or we can wait to see if they respond late. Your call. Wait 3 more days. If they don't respond by April 27th, file. Understood. April 26th, I received an email, not from the company's legal department, from Derek, the plant manager. Subject: contract dispute. Samantha, I received a letter from your attorney. I want to resolve this amicably. Can we schedule a call to discuss? I forwarded it to Michael without responding. He replied, "Don't engage directly. I'll handle all communication." Michael sent a response. "All communications regarding this matter should be directed to me. Please have your legal counsel contact me to discuss resolution." 2 days later, Michael received a call from the company's attorney, a woman named Patricia Nguyen. Michael called me after. They want to settle. What are they offering? 4-week severance, standard release of claims. That's less than I'd make in 1 month under the contract. I know. I told them that's inadequate. They said they'd get back to me. A week passed. No response. I continued documenting. I pulled my original hiring correspondence, reviewed the scope of work I'd been contracted for, compared it to what I'd actually delivered. I'd exceeded every deliverable. Production efficiency had increased 18% during my tenure. Safety incidents had decreased by 31%. Quality control failures had dropped by 24%. All documented, all measured, all attributable to the processes I'd implemented. I compiled it into a summary report, sent it to Michael. "This is helpful," he said. "It establishes your value and performance, strengthens our position if this goes to trial." 2 weeks after the initial demand letter, Patricia called Michael again. Michael relayed the conversation. They're willing to go to 8 weeks severance. Still inadequate? I told them that. They claim you actually violated the NDA and they have evidence. Then why haven't they provided it? Exactly what I asked. She said they're gathering documentation. It's been 3 weeks since termination. The contract required it within 48 hours. I pointed that out. She said the timeline in the contract was unreasonable and unenforceable. Is it? No. Contracts set timelines all the time. If they thought it was unreasonable, they shouldn't have signed it. What's next? I told them we need to see their evidence before we discuss settlement further. Ball's in their court. Another week passed. On May 8th, Michael received a package via courier. Documents from the company's legal team. He called me immediately. They sent their evidence. What is it? 3 printed emails, all from you, all discussing manufacturing processes. To whom? Internal recipients, your former supervisor, the quality control manager, the safety compliance officer. Those are all authorized parties under the NDA. I know. I'm looking at your NDA definition of authorized parties right now. It specifically includes company employees with relevant operational responsibilities. These people all qualify. So they have no case? Correct. But there's something else in here. A memo from Derek dated March 28th, 3 weeks before your termination. It says he had concerns about contractor communications and was monitoring the situation. What does that mean? It means he was looking for a reason to terminate you before he actually had one. I thought about the timeline. Derek became plant manager on March 20th. The memo was dated March 28th. I was terminated April 9th. He wanted me gone from the start. Appears that way. The question is why? I didn't have an answer, but I knew where to look. I reviewed my records from mid-March, the week Derek took over. I found 3 relevant items. An email I'd sent to the previous plant manager on March 15th, 5 days before he left. Subject: safety concern, line 3 ventilation system. I'd identified a ventilation problem that could violate OCR requirements. Recommended immediate repair. Estimated cost $45,000. A follow-up email to Derek on March 22nd, 2 days after he started, same subject, forwarding my original concern, asking for approval to proceed with repairs. Derek's response on March 23rd. Hold on this. I'm reviewing all capital expenditures. We'll get back to you. He never did. I checked OCR requirements for factory ventilation. The issue I'd identified was a clear violation, correctable but non-negotiable. I documented it properly, escalated it appropriately. Then Derek had stalled. If OCR inspected and found the violation, the company could face fines. Derek could face questions about why he delayed addressing a documented safety issue. I sent this information to Michael. This is important, he said. This suggests a possible retaliation motive. You identified a problem that would cost money and create liability. He wanted you gone before you could push harder or report it externally. Can we use this? In settlement negotiations, yes. In court, potentially. It establishes bad faith on their part. Michael sent a response to Patricia on May 10th. We've reviewed the evidence you provided. The emails in question were all sent to authorized internal recipients, as defined in the NDA. They do not constitute a violation. Furthermore, we note that your client's plant manager documented concerns about our client 3 weeks before termination, but failed to address those concerns with her directly, suggest any corrective action, or provide any warning. This pattern, combined with the timing following our client's documented safety concerns, raises questions about the true motivation for termination. We maintain our demand for full contract payment or reinstatement. The letter was professional, but the implication was clear. We know what happened, and we're prepared to argue retaliation. Patricia responded within 2 days. We dispute your characterization of the situation. However, in the interest of avoiding protracted litigation, we're prepared to offer 12-week severance in exchange for a mutual release of claims and continued compliance with the NDA. 12 weeks, $36,000, still less than half the remaining contract value. Michael called. What do you think? Counter with 6 months, $72,000, and I want the termination letter amended to state the separation was without cause. That's a good counter. Let me send it. The negotiations continued through May. Each exchange took 3 to 5 days. Patricia would make an offer. Michael would counter. Patricia would consult with the company. Repeat. May 18th. Patricia offered 16 weeks, $48,000. May 22nd. Michael countered with 5 months, $60,000. May 29th. Patricia offered 20 weeks, $60,000. Final offer. Michael called me. They're at $60,000. That's 5 months' pay. It's reasonable given litigation risks and costs. My recommendation is to accept if they agree to amend the termination record. Will they? I'll ask. He sent the response. Client will accept $60,000 if 1. Termination letter is amended to state separation was without cause, and 2. Client receives a neutral reference letter for future employment. Otherwise, we proceed to litigation. Patricia took 4 days to respond. June 2nd. Agreed. We'll prepare settlement documents. The settlement agreement arrived June 5th, 17 pages. I read every word. Key terms. Payment, $60,000, 5 months contract pay. Termination letter amended to state, contract concluded by mutual agreement, separation without cause. Neutral reference letter provided, confirming dates of service and role. Mutual release of claims. Continued NDA compliance by both parties. Confidentiality of settlement terms. That last point was important. The confidentiality clause applied to both parties. The company couldn't discuss the settlement. I couldn't discuss the settlement. But the amended termination letter and neutral reference were mine, not confidential, available for future employers. Michael reviewed it. This is fair. I recommend signing. I signed June 6th. The payment arrived June 15th, $60,000. Minus Michael's fees, $12,000. Net, $48,000. I'd lost $36,000 in contract value, but I'd gained something else. Documentation that my termination was without cause and a neutral reference. More importantly, I'd established that the company had acted in bad faith. They'd failed to follow their own contract procedures. They'd manufactured a violation that didn't exist. They'd retaliated after I'd documented a safety issue. They knew it, I knew it, the attorneys knew it, and they'd paid to make it go away. I didn't immediately look for new work. I took 2 weeks to review what had happened. The pattern was clear. I'd documented a safety violation that would cost $45,000 to fix. New management wanted to avoid the expense. They needed me gone before I escalated to OSHA or higher company management. They manufactured an NDA violation to justify termination. They failed to follow contract procedures. When challenged, they couldn't prove the violation. They settled to avoid litigation and potential retaliation claims. I documented this timeline, saved it, not to publish or share, just to remember. The system had worked. Not perfectly, not completely, but functionally. I'd lost 2 months of work and $36,000 in contract value, but I'd been made partially whole. My record was clean, and the company had paid for its procedural failures. In July, I started looking for new contracts. Manufacturing process improvement. Same work, different companies. I had 3 interviews in the first 2 weeks. Each interviewer asked about my previous role. I provided the amended termination letter. Contract concluded by mutual agreement, separation without cause. I provided the neutral reference letter. Ms. Hayes served as a process improvement contractor from October 2024 through April 2026. During her tenure, she successfully implemented efficiency improvements and safety enhancements. We can confirm her dates of service and professional conduct. No red flags, no concerns, no questions about why a contract ended early, just professional documentation of professional work. I accepted a new contract in late July. Different factory, different city, same role. Higher rate, $14,000 per month. 6 months after the settlement, I received an email from a former colleague at the Dallas factory, someone I'd worked with in quality control. Subject: checking in. Hey Samantha, hope you're doing well. I wanted to let you know that OSHA showed up here last month. Someone reported the ventilation issue on line 3. Big investigation. They found violations and issued fines. Derek's gone. New plant manager started 2 weeks ago. First thing she did was approve the ventilation repairs. Thought you'd want to know. I read it twice. I didn't respond immediately. I thought about it for a day. Then I replied. Thanks for the update. Glad they fixed the ventilation issue. Safety first. Short, professional, no commentary. I didn't ask who reported the violation to OSHA. I didn't need to know. The ventilation system was a legitimate safety hazard. Someone had documented it. Someone had reported it. OSHA had responded. The system had worked again. I closed that email, opened my current project files. New factory, new processes, new documentation. I was 4 months into a 12-month contract. Production efficiency was up 14%. Safety incidents were down 22%. All documented, all measured, all attributable. My work continued. Professional, methodical, clean. I'd learned something from the Dallas situation. Documentation protects both ways. It protected me when the company failed to follow procedures. It protected the workers when management ignored safety issues. It protected the truth when people tried to rewrite it. I saved my current project files, backed them up, encrypted them. Then I closed my laptop, made coffee, checked my calendar for tomorrow. 2 client meetings, 1 site inspection, 1 process review. Normal work, proper contracts, clear documentation. Exactly as it should be.